two of the greatest threats are ransomware and business email compromise. Everyone pretty much knows what ransomware is today. The bad guys encrypt data and then want ransom payment to get the decryption key. The second step of that is becoming more frequent is, in addition to encrypting the data, they steal it and want extortion payments so they won't sell or release it. Business email compromise is another great threat to law firms. That's using fraudulent emails, often taking over a law firm's or clients or someone else in a transaction's email system and sending emails that come from legitimate addresses, trying to steal information or to do something like getting fraudulent wire transfers. These are probably the two greatest attacks hitting law firms today. That over 90% of successful cyber attacks start with a phishing email. So if attorneys are aware of emails and employ technical and procedural defenses against them, it's hitting a high percentage of the attacks. This figure comes from CISA, which is the Cybersecurity and Information and Infrastructure Security Agency that's part of Homeland Security. The other stat is that about 68% of breaches include a human element, emphasizing the importance of training and cybersecurity awareness as part of defense. This is from Verizon. It has an arm that does cybersecurity consulting and breach response, and every year it publishes a data breach investigation report that summarizes what's happened and the lessons learned from it. So these are important numbers in terms of developing a cyber defense. There are four sources of our duties. First is the ethics rules, and if attorneys violate them, they're subject to a disciplinary action. Next is common law, and a violation of those can lead to a malpractice or professional liability action. Next are contracts. Particularly clients in regulated industries are now more frequently having specific contractual cybersecurity requirements for their attorneys. And finally are laws and regulations. Those generally deal with defined kinds of personally identifiable information, but they apply to attorneys as well as others. Another category I don't have here is we're now starting to see some court orders that are confidentiality orders and protective orders in litigation that, in addition to limiting sharing of the information, also provide for security and require notice in the event of a breach. So it's important to understand that these sources of duties set minimum standards, and conduct below them can be unethical or unlawful. And the goal in practice should be aimed to be well above these minimums as a matter of client service and sound professional practice. All right, so turning to the specific ethics rules, there are three and then a group that apply. First is Rule 1.1 on competence. And that requires attorneys to have and maintain competence in the law and in its practice. The comments to Rule 1.1 provide that includes understanding the risks and benefits of relevant technology. So it specifically applies to our use of technology. Next is Rule 1.1 on communication. It requires communication with the client about material aspects of the relationship, and it can, so something like using AI, it probably requires communicating with the client about it and perhaps getting informed consent from the client. Significantly, it also requires, in the event of a compromise or loss or compromise of the confidentiality of client information, it requires notifying the client what has happened. 1.6 is confidentiality of information. It requires attorneys to take reasonable efforts to prevent inadvertent access to confidential information and to protect against unauthorized access to it. So that's the protection against hacking. And finally, 5.1 and 5.3 require supervising attorneys to ensure that everybody within the law firm, whether they're attorneys or others, and everyone outside the law firm working for them, provide their services in a way that is consistent with the attorney's ethical obligations, including communications and confidentiality. Attorneys should have a comprehensive cybersecurity program. And that's true whether you're a solo practitioner or you're in one of the Am Law 100s or 200 biggest firms in the world. But ABA guidance says that the program should be appropriately scaled to the size of the practice and to the sensitivity of the information. So a solo might just need a couple or a few pages, with kind of an outline that they work with their IT people on or their IT consultants. For larger firms, it can be something rather lengthy and detailed. It should be risk-based. And the comments to Model Rule 1.6 go into some of the factors that are determined in a risk-based program. Importantly, it should address people, policies and procedures, and technology. It's not just technology. And a lot of people, both attorneys and others, mistakenly think that cybersecurity is primarily technology. It's a critical part, but going back to the earlier slide with the phishing and the human element in breaches, if you don't address the people part with training and security awareness, technology very well may fail. So training is important. The program needs to be periodically reviewed and updated. And again, constant security awareness. One critical thing to take away from this presentation is that constant security awareness all the time is just a critical part of cyber defense. So a cybersecurity program is best based on a standard or a framework. So instead of looking at different types of security on an ad hoc basis, like looking at passwords and antivirus software and things like that, it's best to use a framework, either to completely comply with it or to use a guide. So the first two are from NIST, which is the National Institute for Standards and Technology, that's part of the Department of Commerce. ISO is the International Organization for Standardization. It has a series of very detailed cybersecurity frameworks. The Center for Internet Security is a nonprofit that publishes what are called the CIS controls, which are a list of specific coordinated cybersecurity controls. And finally, ILTA, which is the International Legal Technology Association, has a LegalSec initiative that takes these kinds of standards and translates them for the legal profession to manage and minimize your data. Because if you don't know what you have and where you have where it is, you can't protect it. And one of the biggest challenges that we have when we're called in to assist with a data breach is understanding what technology and data the victim has and where it's located. And oftentimes we'll have to do that on the fly as part of the breach response. The more of that you can have in advance, the easier it is to both protect it and to deal with it if there is an incident. Next is to classify the data. And that means to take at least the most sensitive kinds of information. like Social Security numbers, trade secrets, things like that. Make sure you know exactly where it is, and it is protected beyond routine everyday data. Next is to minimize collection and retention. If you don't need it, don't collect it and retain it. Next, segment and limit access to highly confidential information. If you're representing a company in IP litigation, does a receptionist need access to that information? Or does a receptionist need information to tax information if you have a tax or trust and estate practice? And finally, secure disposal. When you no longer need it, that's either shredding it or wiping it securely electronically so it can't be retrieved. So again, if you know where it is and protect it, you're way ahead in both cybersecurity and in breach response. All right, staying current. This is a real challenge, but when flaws are discovered in software called vulnerabilities, attackers can often exploit them to get by security. And it's really an arms race between the bad guys finding vulnerabilities, finding out how to exploit them, the company that develops the software learning about that, coming out with patches and getting people to install them. That there have been a lot of major data breaches where updates or patches are available to protect against exploits, but they just haven't been installed. And Microsoft comes out the second Tuesday of every month. We just had one yesterday with what's called Patch Tuesday, and it has the updates. It's important to do it for the operating system, whether that be Mac or Windows, and for all your software. So it's a challenge to do it. It's best to upset to enable auto updates, and it's best, if you don't know how to do it yourself, to have an IT consultant periodically make sure that your firmware is updated. That's the embedded software in computers and devices that actually run the computer, and security updates periodically are published for them. All right, so one of the common threats is insider threats. And again, going back to the slide that about 70% of cyber incidents involve a human element, a lot of those are insiders in a law firm. It can range from being dishonest or malicious to someone just being rushed, multitasking, and things of that nature. It's a pretty small percentage that is malicious or dishonest, fortunately, but that means that the higher percentage are people who are trying to do the right thing but make mistakes. So you want to vet new hires. That's for honesty. Having training, initial, periodic, and reminders. In a solo firm, that can be attending programs like this, reading some articles, from the ABA, from the Bar Association, things that cyber insurers publish, but having some way of keeping up to date. Monitoring employees if you're beyond a solo, and dealing with departing employees, particularly making sure that they don't have passwords, digital copies of files, and things like that. As part of your incident response plan, have information on the FBI's Internet Crime Complaint Center, that's IC3. If you send a fraudulent wire transfer, in addition to notifying your bank, get online and notify IC3, get the bank numbers and everything in there. If they get the information timely for domestic banks, they have a 75% success rate in stopping the transaction. And then finally, constant security awareness by every user, every day, every time they use technology. Think before you connect, click, or act. This is the constant to best protect against cyber attacks and losses.